Good morning, everyone. Thank you so much for joining us this morning. Pardon us for the slight delay in beginning, but thank you very much for joining us for today's workshop with us, Nairobi Garage. It is such a pleasure to be here today, and we appreciate you taking the time to engage with us in this forum. My name is Victor Muthama. I'm the community manager at Nairobi Garage Spring Valley. For those of you who might not be familiar with Nairobi Garage, just give me a second to tell you a bit about who we are and what we do. So Nairobi Garage is Africa's largest and coolest working space. We are an innovation center and a co-working community that thrives on growth, innovation, and learning. The flexible working spaces at Nairobi Garage give you a business space to grow, gets you connected with a large network of similar-minded professionals to increase your impact and your scale. Our spaces offer a variety of amenities, including fully furnished office spaces, breakout spaces, reliable internet, and bottomless coffee to give you fuel for the whole day. We're a virtual network of 2,000 plus entrepreneurs and professionals. We're home to more than 200 high growth companies. We have weekly and monthly events that we use to build our business community. And we have 5 central locations right now: Kilimani, Karen, Spring Valley, Westlands, and newest CBD. So we believe that co-working drives innovation because wherever people share physical spaces, they are able to collaborate and create things they wouldn't have otherwise on their own. We host workshops like this every month to expose our members and the larger business community in areas that they can explore that might be of interest to them, that they might want to learn from. Today, we're going to be talking about something very interesting. We're going to be talking about what legal processes do you need to be aware of when you're starting or if you're already running a business venture, especially as a startup and especially in a tech or a tech-related field? We are going to be having some exciting panelists. I'm going to give them some time to introduce themselves, but just to tell you a bit about who we have today in our workshop, we're going to be having Jomo Kamau and Rachel Olenga from Netsheria. Netsheria is an online legal services platform that provides top-notch and cost-effective legal solutions to entrepreneurs by leveraging on technology. They offer legal support necessary to launch and grow startups, protect their ideas, and realize their business objectives by offering voice of experience and a guiding hand to young companies as they develop their products and services and successfully move from ideation to the market stage. So without further ado, and just so we can jump straight into it, make sure you have your notepads ready, have your pens ready. We're going to be learning a lot today. This is a lot of information that you don't want to miss. We're going to be also taking some of your questions on the chat box. Engage with us, comment, share your feedback, share your thoughts, leave any questions that you might want to have addressed. But without further ado, I'm gonna allow Njomo Kamau to come on stage and take it away from here. So thank you again for joining us. I hope we're gonna learn together, all of us. So please, Njomo, take it away.
Good morning, ladies and gentlemen. My name is, and thank you, Victor, for the introduction. My name is Njomo Kamau. I'm a director at Netsheria International. Vic has explained nicely what we do. So basically, we aid startups, entrepreneurs, give them the legal support and advisory services that they require to leverage, to grow and scale their businesses. And that we do through providing access to cost-effective legal documents, cost-effective legal consultation services, and also legal retainer services for a wide variety of legal services through our entrepreneur club retainer model. Today we are speaking about various aspects relating to the legal contracting and what is required for business as you start off. So we'll go through a wide variety of topics, including the how to finance the business, looking at the contracts and what is required for day-to-day running of the business through contracts. Sorry, a minute. Thank you. So the topic today is about demystifying legal processes in your entrepreneurship journey. So we look at a wide array of topics today, including what to look out for in contracts, also understanding the underlying truths about investment in your business. What do you need to do to look at when you are considering how to get investments into your business, how to tighten any loose ends in your legal processes. So this looks at how your business is compliant in its legal processes and what you need to do to put in place from a management point of view and a business point of view to make sure that you're compliant as you carry out your business. The other thing we look at is things that you cannot afford to ignore when setting up structures for your business. So a lot of times when people set up their businesses, then they only look at the fastest way to get to market, to start making money, to get their products and services out there. But then sometimes you don't look at some key things that sometimes you can come back to affect you later as your business grows. The other thing we look at are the advantages of having written contracts. Of course, all businesses need contracts for the services and products that they provide. And we look at why those are required for the business and what the pros and cons of those are. And of course, also then followed by that will be the disadvantages of not having written contracts. How can your business be affected if you do not put in place the relevant contracts to help you run your business? After that, we'll open up to a question and answer session, but also what we'll be doing is as you go along, we'll invite you to ask your questions. And as stated also, I think there's a chat section. You can raise your questions on that, and you'll be able to take them in the middle of the session or at the end of the session, depending on how we progress. So without further ado, let me get into it and just start on the introduction, what is required for businesses. So there's been a growth in the number of startups in Kenya and across Africa, people who are starting off businesses from scratch, founding businesses, and they're getting them up and running. And with that, there's a need to understand what it takes for them to grow, to leverage on the existing opportunities without ignoring the basic underlying requirements that they need for them to grow and scale to become top-notch business enterprises. So for this, one needs to understand how both the micro and macro dynamics of the business, so which begins from when the business is incorporated, when it starts, and continues through its growth, and finally, hopefully not to its winding up, but basically I can say to its success, to greater and bigger success, because the idea of this is to set in place a foundation that allows the business to grow to a level where it's able to sustain itself and multiply and become bigger than the founder's dream or vision and outlast the founders for many generations to come. So for this to happen, the success of every business has got various foundations. So the first one is how well are you legally aware through your contractual relationships. So a lot of times, as I said earlier, we start off businesses, and our first thought is how do we get products and services to the market in the most cost-effective manner, the fastest manner, so it can break even as fast as possible. But sometimes you overlook some very basic fundamentals, like for example, if you're starting off working with suppliers or with customers, do we have in place the relevant contracts with those suppliers, with those contractors, with those customers, that will ensure that we keep a record of what the expectations of our business are, what the expectations of the customers are, and that enable you as a business owner to track where you're going wrong, where you need to change, or the things that you need to improve on. The second part is how best to understand the investments in your business. So of course, every business requires investments to grow. And these investments can come in various forms, starting from your own personal investments to having to look to third parties to finance the business. And if one does not understand what underlies these investments, then that can be quite costly for the business, because one, you can end up taking very costly financing for the business, or you can end up underfinancing your business, or you can end up taking financing that comes with very terms and conditions that end up affecting the business. So every business operates within a legal context. If you look, you do your due diligence as you set up your business, you'll find at some point there are various laws that apply to the respective business that you perform, starting all the way from the Companies Act, that is the foundation for each company that is formed, all the way to now the specific laws that affect the business line that you're in. Of course, you have general laws like, for example, the Employment Act. You have all these things like Environmental Health and Safety Act, the Workmen's Compensation Act, the Work Injury Benefits Act, things that affect your businesses, your employees, as you move along. And those you need to look at and understand. There also are the things like company secretarial laws and regulations that you need to comply with, that are set from time to time, that also need to be adhered to, and have the relevant professionals help and guide you business. What should you take into account? Every business needs more, in the end, more than one person to succeed. You'll find that you cannot do everything in your business. You will need someone who can do your finances. You will need someone who can help run your operations. You'll need someone who can help guide your legal processes. You'll need someone to help you guide your strategy, someone to help guide your commercial operations. So as a business grows, you realize that you'll need to put in place the right people and the right structures that help that business flourish and grow. So that is a very important aspect to take into account as the business starts. So the first step is what to look out for in contracts. So for business to be legally aware, you need to have proper contractual relationships. So what is a contract? So basically a contract is a legally binding document. So it's a document that is signed between the business owner and the person from whom the business owner requires a good or a service, or a consumer to whom the business owner is providing a good or service, has various elements. So the first, is that it must contain an offer that is made from one party to the other. So this basically must state what service or what good is being provided by the business owner to the third party. And the contract is important in this regard because it is necessary that one clearly stipulates the exact service, the exact good, because a lot of times people end up providing or thinking they're providing a certain good or service, only to realize that that is not what the other party needs or wants. It must also contain an acceptance of that offer. So it must be very clear that what has been stipulated as being offered by the business owner is accepted by the other side. So by the other side signing the agreement, they then confirm that yes, we agree that we shall accept this good, or we require this good or this service as indicated in the contract. There should also be a form of consideration. So it means that for each good and service that is given, there is money that has to be paid. So the consideration normally is in monetary form, can also be in the form of another service being provided, for example, like a barter trade of sorts. But more often than not, it is that in the form of some kind of monetary payment that is made by the party receiving the good or the service. So the offer should be made in exchange of some form of payment. The fourth part, and which is very important, is that each party must have the capacity to enter into contracts. In this case, they should be adults, or in the form of in the part of business corporations, they must have the relevant support in terms of the directors and shareholders who are going to sign off on that agreement. And they should also be of sound mind. So whoever is signing off must be clearly aware and be able to sign off on behalf of the party providing the good or the service. There should also be a mutual agreement by all parties to enter into that contractual relationship. So this is very important because sometimes you think you want a service or a good, and then you enter into the contract and realize, no, I did not need this good or the service. So one needs to clearly understand that this is a particular good or particular service that I require for my business, and the way it is encapsulated in the contract is what I require or what I need. And on the side of the party providing the service, they must also be aware that that is a service or a good they can provide, because a lot of times people say that they can provide a good or service, and then they end up realizing that they actually overpromised. They are not able to provide that good or the service to the extent that is in the contract. So it is clear from the foregoing that the contractual relationships are the foundation for any business undertaking. And of course, in this regard, the key importance of the contract is the binding effect it has on the parties that enter into that contractual relationship. So by each party signing that contract or that agreement, they basically make an undertaking that we shall provide that good or service, and on the other end, the other party shall make the payment for that good or for that service as stated. So the contract therefore binds parties to the enforcement of the terms and conditions of that contract. It means that later, if you look at what you're providing and you realize that you're not providing to the status to the extent and stated in the contract, then it means that you're in breach and that you must, as fast as possible, be able to make amends and provide the good or service to that level as provided. The contract also then therefore provides protection to any party aggrieved or that's at risk of being aggrieved as a result of the breach of the contract. So as stated earlier, the breach occurs when one side does not perform its end of the bargain. And this can, of course, from the product or the goods part, that provision is not adequately given. And on the other end, the payment can also not be affected because of breach, in sense of there's a delay in the payment, or where, for example, the other party refuses to pay because they feel that the good or the service provided is not to the level expected. So further to this, the contract is a shield to protecting parties against any liability, so loss or harm that may arise when the other party breaches a contract. So you see, in the event that one party does not provide its end of the bargain, the contract then gives you some form of assurance that yes, because you undertook to provide that good or that service as stated in the contract, there is a protection afforded to me. Then I can then go to court or then have a remedy through the various dispute resolution mechanisms provided for in law to ensure that my rights are protected, that the other party does provide the good or service as required, or on the other end, if I provided the good or the service, that the party receiving that good or service is entitled to receive the payment, the full payment for that amount, for that service given. And where one party feels that the service or good does not meet the value paid for, then there is a form of remedy provided in the contract. What needs to happen to make sure that the other party then feels that it has received the full value for that service paid or good paid for. So the parties that enter into a contract should understand the terms and conditions of the contract before signing it. So in this regard, there is a need to engage the right professionals to provide the relevant advice before this contract is signed. So a lot of times people just think that a contract is something that, okay, I just need to consult a lawyer, and once I do that, then the contract is fine. However, it is important to know that a contract is merely an underlying document that provides for a commercial relationship between the parties. So of fundamental importance is to understand the good or the service being provided and that it's going to be paid for. So in this regard, the first thing is to have a sector-specific advisory. So if, for example, if you are requiring services of an architect, it is important to understand what is an architect supposed to provide for me. If I want a house built, what is the scope of the service? What should I expect? So in this regard, it is expected that you, as the person requiring the service, should engage, do external due diligence to try and understand what will I require from this architect, so that when I'm signing off, I make sure that the obligations set out in there are very clear. The same for service. If a service is being provided, do I understand the service that I require? A lot of times, a lot of people just give very sketchy briefs of a service, and then later they say, no, you did not meet that, what was the service, the expectation which was required. And a lot of times that will come down to the fact that when this good or the service was being defined in the contract, that was not clearly stated. The other part is the financial advisory. A lot of times people do not engage the right professionals from a financial perspective, especially when it comes to the issue of the payment and how the payments are structured, how they're broken down, understanding the tax components of that payment. So you find that, for example, someone will say, they want their payment payable, exclusive of taxes, but because of not consulting properly, you find that they end up taking the payment including tax, simply because of a simple writing, or one or two that is missing. So it is in this regard, it is important that when that financial obligation is stipulated, it is passed through a financial advisor or a tax advisor to then have the person understand that yes, indeed, this is what you're expected to meet when it comes to that part of the payment in regard to the financial and tax obligations. So just to break it down further, contracts have got various provisions, which I will briefly take you through. And so they expressly provide for most of the following terms. First are the terms and conditions. So these are the guidelines which refer to the contractual rights and obligations of a party to any contract. So these terms and conditions are very important because you'll find that, for example, when it's some specific goods and services being provided, you'll find that they will say that the goods, once purchased, cannot be returned, or they'll stipulate the conditions under which, for example, the goods can be returned or have service done on them once they are sold. And a lot of times customers end up entering into these contracts without paying heed to these terms and conditions. There's also the argument that, yes, sometimes they're very voluminous, they're written in very small text, but it is important for the person who's acquiring the good or service to take their time to sit down, to go through those terms and conditions, and where there is doubt or they're not clear what is expected, to either ask the other party for clarification or, as I said, to engage the advisors who I stated earlier, the legal advisors, the tax advisors, financial advisors, or the sector-specific advisors to then clarify. So you'd rather take time to have that contract drawn up, to go through back and forth explaining things, and sign a document you understand, whose terms and conditions you understand, than signing onto a document and then saying later, no, I did not see these terms and conditions, but you find you are now bound by them. The parties to a contract. Each contract must expressly stipulate the parties to that contract, whether they're natural or legal persons. It is important to note that the only people who can benefit from a contract are the people who sign to that contract. So if a contract is to benefit a third party, it should be very clearly stated, and as much as possible, you should also have that third party sign on to that contract, especially if they've also got obligations to meet for them to enjoy the benefit of that contract. The parties, as also stated earlier, must have the capacity to contract. So we all know that you must be an adult of sound mind, at least over 18 years old. And for a company, if you're a director, you must have the relevant authority from the shareholders or from the management of the company to execute that contract. It is important to know that a contract can be made void simply because the person who signed that contract did not have the capacity to make that contract. So before you sign, make sure, does the person who's signing this contract have the right capacity to do so? If so, then the person can proceed to sign off. It is also important, as much as possible, to try and get your signatures witnessed by a third party, so that in the event that there's any concern or there's any doubt as to whether the right party signed the contract, there's also a third party who can be consulted to confirm, yes, this person did sign, this person did have the capacity to execute that contract, and that the signing was properly done. The third part is dispute resolution process. So where there's a contractual relationship, we assume that, of course, everything will go smoothly, but a lot of times, more often than not, sometimes just due to some simple ignorance, or sometimes due to parties not understanding what is expected of them, there is a breakdown in the relationship. So you'll find that at some point a dispute arises because the parties don't understand what is expected, or that then there is a disagreement about what has actually been provided. So in every agreement, it is imperative that there is a clause that seeks to handle those disputes that arise. So this can be done through an arbitration clause. But I should also note here that there's also been a push lately to try and have parties mediate the differences. So you'll find that most agreements have a three-part dispute resolution clause that provides for one, a mediation element where the parties can sit down with a third party who is not an advocate, who's not necessarily a lawyer, but whose job is to try and get you together to try and discuss and address the issues that have arisen, that have brought up that dispute, and in a friendly and relaxed manner, so that then the parties in that way can try and resolve that issue. The second part is then where it goes to the mediation, to the arbitration process, where when the mediation fails, we then engage a third party who has this almost the status of a judge, but then the arbitration is still done in a very amicable manner, but following very set legal rules. And the award that is then given is an award which is binding and can be enforced in a court of law. The fourth part is another important clause called limitation of liability. So this clause seeks to first to limit and also to assign liability in the event of any breach by either party. So you'll find, for example, if I then sign up to a contract with a value of about 1 million shillings, it is important to note that there should be a clause in that contract that states that, yes, because that is the amount that I get, I am going to put in place a clause that limits the liability that you can achieve in the event that I breach that contract, so that I don't end up also going at a loss, so that your liability does not go beyond the 1 million shillings that I've signed up to. The next part is confidentiality. So in every contract, it's important that each party's rights and duties and obligations and in that contract are also kept secure from external interference. So basically, this clause of confidentiality provides that the contents of the contract are reserved to the rights of the parties. So this can take the form of a non-disclosure agreement by which each party undertakes not to disclose the terms of that contract or that discussion in the contract setting to a party which is not party to that contract, to any third party. The next part is the force majeure clause. This clause is also very important, but also very overlooked. So this clause seeks to remove liability for unforeseen, unforeseeable, and unavoidable catastrophes. So basically, acts of God that interrupt the expected conduct of the parties and performance of the contract and prevent them from fulfilling their obligations. So these take the form of things which are outside the party's control. For example, where you have earthquakes, floods, strikes, political riots that can make the good or the service that has been contracted for not be able to be provided. So this is where it's not that the person providing the service or good is not able to, or does not want to. It's that an external force or a third, something outside their control has stopped them from performing that good or that service to the person who requires that good or service. So it is worthwhile to note that the obligations of the parties in the contract must also be expressly defined. So as much as possible, where you cannot put all the terms and conditions or what the exact terms of that obligation in the contract, you also allow to have it in the form of annexures or schedules that are, for example, more detailed. So in many cases, you'll find that the actual contract document is a very small document of a few pages, but then you find the schedules and annexures run into several pages. But then those then clearly state what is required in terms of that good or that service, especially when it comes to a good that is being provided that is very technical and that needs a very big description for the other parties to understand what exactly is being provided. So all parties are therefore required to have their rights and their duties spelled out in that contract very clearly. So we come to the next part. Having gone through the contract part and assuming now you've then entered into your contracts, we come to the part where we say, trying to understand what forms investments in your business. What are the truths about the investment in a business? So from an investor, maybe at that point, I'm not sure if there are any questions, having finished the contract part. If there are no questions, I think we can move on. So as I said, we're looking into the issue of the investments in a business. So from an investors and a business owner's point of view, so one must take great care and attention before making any decisions regarding investment in that business. So in this regard, an investor or a business owner must understand the the following salient points about investment. First is the issue of a due diligence. I think these are words which are normally said, and a lot of people sometimes don't understand what a due diligence means. So a due diligence means basically doing a background check into an issue. So in this regard, one must also be sure that before making an investment in a business, that the business is legally compliant. So one way to do that, the first way to do that is to conduct a company search to make sure, first, is this company properly incorporated? Am I dealing with the right entity? A lot of times you can do a company search and realize that actually this company is not in the right structure, or 1, 2 does not exist, or 3 that the persons who are stated therein as the directors who I'm dealing with are not the correct persons, and I'm actually dealing with people who are not the right people. So a lot of times, a lot of red flags are raised through this company search, which comes out in the form of a CR12 when it's done on the eCitizen platform. So that document will still tell you what entity you're dealing with when it comes to a corporation. So, for example, it will then tell you, when you get information about the name and address of that entity, is it correct? Is it correct what I'm seeing? For example, if I'm told the office is here, but then I find out in CR12, for example, that in the search that the address is somewhere else, it opens up an element for me to search, to look into. Is this the right party I'm dealing with? The second part is, what's the company's registration number? This is very key, because a lot of times this number is what gives the company that legal stature in the company's registry. So if you find that it's a wrong company registration number, it means that you're probably dealing with the wrong business entity. So it is always important through the search to confirm that the company number in the search relates to the information which has been given, and that it relates to the right company that I'm dealing with. What is the number and the type of shares? The shareholdings are also a very important part of this business. You may have been promised and told, okay, I'll give you X number of shares. But when you do the search, you realize, oh, the company does not have the number of shares. All the shares have already been provided, or you'll find that it has the wrong type of shares are what are being given to you. So that also opens up a possibility for you to discuss with the other party, and then be clear. You say you give me this number of shares, or that you invest this amount of money, I get this number of shares. But I see, for example, that all the shares have already been allotted. How am I going to get these shares? So then that gives rise to other business agreements that have to be entered into to ensure that I get my stake. Another important part is who the company's directors and shareholders are. I think we've seen in the media recently, especially when it comes to a lot of contracts involving the government, you find that the parties who are dealing with the government have different shareholders or directors from the people who they believe they were dealing with, and this can also occur in the private sector. So it is always important simply not to go by the fact that someone says he's a director, but to confirm from the company search that the person stated is the actual director or the shareholder in that company. And lastly, for the shareholders, what is their shareholding? If you're a shareholder in the company, again, what is your exact shareholding? This is very important, because you'll find that the more shares you have, the more control you have in a company. So where a person has more shares, it's imperative for you to ensure that you are dealing with that right person, so that you get the correct consents and know who the actual decision makers and approvers in the business are. Further to this, as part of the due diligence process, an investor should also request for financial information from the business, which normally comes in the form of financial statements. Now, this is something sometimes that is left only to accountants to request. So as a layman, you may say, okay, I don't understand what these financial statements, the profit and loss accounts, the cash flow statements mean, or to me. Then this is why I said earlier, you now then engage the services of a third-party consultant, for example, an accountant, who can help you go through the figures and make sense of them, and then basically understand, is this business worth investing in? Is it making a profit, as it's saying? Are these numbers solid? And does this give me enough ground for me to make that investment in the business as I've been requested to do? The other part of this then also involves conducting a legal and secretarial audit. So the legal audit, basically, as stated earlier, is just ensuring that the company is compliant with the various laws that govern its operations in a marketplace. So where, for example, a company is governed, it's a mining company, then you then want to ensure, do they have the correct licenses under the Mining Act? Are they performing the obligations as stipulated under the requirements of the Act? And these are very important because where a company then is not compliant with the underlying provisions of the laws that regulate it, you may find that then it's subject to sanction by the industry regulator, which will then affect your investment. If you made an investment, you find you may, for example, lose it all if the company's license is revoked for it not meeting its obligations as provided for under the respective acts or laws. The investor should also look into whether the business has the necessary certifications from the relevant regulatory bodies, as stated, the licenses and approvals. And this can also be done through those regulatory bodies. You then come and say, this company has requested me to make an investment, and they can actually then confirm for you that the company is actually compliant with the laws and it's a sound investment decision to make. So this also is industry dependent, and this also ensures that the company does not engage in any illegal dealings. The other part of this is also the secretarial audits, as stated. So secretarial audits basically ensure that the company is compliant with the provisions of the Companies Act, which is the underlying foundation for every company. So basically, are its directors properly appointed? Does it hold its meetings in accordance with the Act? Does it have the relevant resolutions and filings as provided for in the Act? So this secretarial audit will confirm that the company does meet the obligations set out in the Companies Act, and that basically has the right foundation for the investment to be done from a corporate perspective. The second part of the investment of investing in a business, of course, comes to the issue of the fundraising options. Once one has done the due diligence in the business and confirmed, yes, this company has been properly formed, its books are in order, it complies with the Companies Act, all its secretarial filings are up to date and in place, the directors and shareholders are correctly stated, and basically the company has a correct legal format as it has stated. The next thing to look at is then, okay, to understand what finances do I need as a business? What finances do I require to get from external parties to put into my business for it to grow? So the business owner then needs to understand the various modes of raising capital for the business and the consequences for this. So in this regard, the first key element in financing is looking at the issue of your own personal savings. So before you start a business, it is important to find out how much am I myself willing to invest in this business. And it is we always say, yes, start off with what you have, but it's important for you to first do a kind of analysis to find out what will be required to start off this company. At a basic minimum, you'll find you'll need money to first incorporate the company as a legal entity. Then you'll find you'll need money to apply for the initial licenses. And you also need money, for example, to hire the first professionals to prepare the books or then to carry out the first audit on the company. The next thing once you then have looked at your own sources of investment, the next thing to look at is financing from family and friends. That is the next element that most people go to, where they then say they go to the immediate family, to the extended family, and try and find out if those family and friends can provide them with loans in the business. Now, these loans will most often take the form of a stake. The family and friends may say, okay, I'll give you X amount of money, but then I want a stake in that business. So one then must also then note, based on my initial share capital, how I've structured this company. How much stake can I give to family and friends who give me money? So that then in the end is to find to make sure that you keep the control. So as much as possible, where you have your own savings that finance that company, of course, then you have maximum control. But the more people you bring in as third parties, then the more control one cedes. So it's important to then get the services of an external advisor to value the company, the share, and then find out that when someone invests an X amount of money in my business, that entitles them to a certain stake in the business. It's also noteworthy that for each stake, for each amount that is invested, the person investing may require more than just that investment, and they may want to have a say in the running of the business. This can take the form of saying, I would like to have a director appointed, or I'd like to participate in the business myself to basically ensure that my stake is protected. The third part is where you then look to third-party entities to provide you with money, and this takes a form of credit, overdraft, and then going into bank loans. So credit overdraft can take the form of where you have your own savings in a bank. You then approach the bank to then say, okay, can I take some form of credit or overdraft on the amount that I already have here so that I can grow the business. Again, with this, it is important to note what terms and conditions apply to this credit or overdraft. So whereas the entity providing the credit or overdraft may not require direct stake or say in the running of the business, they may require some form of security for them to provide that credit or overdraft. This also is the same for the bank loan. And of course, the more the loan that's taken, the more conditions the entity providing the loan will require from you. So again, before this loan is taken, please, it's important for the person taking the loan to get external advice. Take your time, go through the loan documents clearly, understand fully what's at stake for me. If I take up this loan, what is the security provided? What do I risk losing? You'll find a lot of times that for the loan to be provided, you have to give some form of personal security in the form of, for example, a title deed for your house, for a parcel of land you own somewhere. And in the event that you default, or your business defaults in repaying that loan, then those personal assets are at risk of being sold by the bank for them to recoup their money. The other form of investment it takes a form of equity investors. So these are third parties who then have a pool of money and they say, look, we are willing to invest, to make a pitch to them, and they say, we like the business idea and we'd like to invest in them in that business. So again, equity investors also come with their own expectations. Some may want to participate in the business. Others may state that they simply want to put their money in, but then expect you to give them the return within a particular point after some time, and they may not necessarily require some form of security as the banks do. The next form is venture capital. So this now takes a form of seeking out third parties who have access to vast amounts of capital, who then take an interest in investing in your business with the aim of growing the business to also maximize their own profit. So whereas an equity investor may say, okay, I just want to get my return and get out, a venture capitalist may say, I want to be part of the business and grow with it, so that it can come to a form where in the end they can sell the stake for profit. The other part is a new provision in fundraising, which is a crowdfunding, which is now provided for under Kenyan law. This is where a person requiring financing in a business is able to then get access to a pool of people who have got money, and basically have those people invest in the company. It should be noted that this crowdfunding has now taken the form of a legal has got a legal status in this country, because now there's a certain application to be made through the treasury, and there are regulations that provide the amount of money that someone can require, and the obligations and rules that one must meet for that funding to be met. And this is done to protect the investment of those people who are investing in that business through the crowdfunding platform. The next part is also understanding the implications of raising the capital from investors. So it's important to know that where you get money from an investor, the investor can treat the facility as a loan, which would attract interest at an agreed percentage. So as stated earlier, so this it should be very clear from the terms and conditions and that one has signed up to. What does the person investing in your business want? So the terms of the loan agreement are terms that should be clearly understood, and third party advice obtained from the lawyers or from accountants or from financial advisors before one signs up to obtain that loan. The investor can also demand equity in the business. So this means that where the investor puts in money, where the facility is issued, there is a structuring or shareholding that the investor gets in the business. So this takes the form of the shares according to the sum injected. And this then affects the control of the business by the owners, as stated earlier. The more funding that is provided, the more control that a party wants, the more the more the party will want to have a say in the business. So it is important to the party requiring financing or funding to actually do a proper evaluation of the business to ensure that they get the correct amount of financing for the shares, and that that financing is structured in a way that the control of the business is not ceded by the business owner. And where that control is ceded, then what happens is that there's a dilution of the shares in the business, and thus the business owner will have to enter into contracts that prohibit such dilution of shareholding, that protect the control of the shareholding, for example, by ring fencing a certain amount of shareholding to only be held by the business owner or the founder. The third part is the operational and management strategy for the business. So the success of every business is premised on how well the owners are organized. So this involves the owners putting in place the relevant policies for the business. So these take the form of HR processes, operational policies, commercial policies, financial policies for the day-to-day running of the business. So initially, these may not look to be very important, but you find as the business grows, these are the policies that will determine how the company will operate in regard to its structures. So you'll find that where there are no policies in place, more often than not, you'll find that there are loopholes that will lead to financial loss for the business. So that part, as stated, as earlier alluded to, was whether the business has a business plan. So a business plan is a very technical document which is prepared with the help of third-party advisors that states the goals and objectives of the business, looks into its financial capability, looks into its strengths, weaknesses, and operation technicalities to ensure that the business is a viable prospect. More often than not, when you were trying to get a third party to finance the business or to fund the business, they will want to understand what is this business about? What does it do? Is it viable? Is it a business that I can put my money in? Does it have the sound structures and policies and processes in place that will allow me to have my interests secured? So it is important that in this regard, at the state of business, the business has a business plan, and that plan can and should be refined on a regular basis through the meeting of the management and the shareholders and directors of the business. I'll open the floor to any questions if there are any. If not, then I'll hand over to my colleague, Rachel, to move on to the next part.
Thank you so much. You're welcome. My name is Rachel Olinga, and I'm happy to be here to be able to share some of the things that can help us in our businesses. And just as my colleague said, and just in a nutshell, is that you need to really understand what your business entails. You need to understand what you're going to, and also to summarize everything as a business person, any business that you're entering into, even if it is talking, conversation, as long as you have ideas, all those things have to be put in writing. All your ideas, everything that you agree with the person you're going to enter into business with, it has to be in writing because one, it will help you to follow up your business and to make sure that you don't get shortchanged at the end of the day. So having your businesses and having to understand the terms that are moving with it really helps you to build up to the next level. And also, even as you realize one of these things when you're dealing with investments, the things that you need to look at, as previously discussed by my colleague, is that if you are not well organized, the investors will see. So you need to know your way around what kind of investments that you want, the investment you want. Do you want a family to help you? Do you want to go for venture capital? Do you want friends to be the ones to help with your business? Do you want to take a loan from the bank? Or are you going to deal with crowdfunding in order to make sure that you are able to run your business smoothly without having issues? All these things, when they're in place, then your idea is now becoming something bigger and it's now beginning to materialize. So one of the things that, like we said, is to tighten the loose ends in your legal processes. One of the things in order to do that, as we can see before we go down, is that have you already gotten a name for your business? Have you opened a business, registered your business for people to be able to, for that you can have an address and a place for people to come to? If not, these are one of the quick things that you need to have. Because when you are having a business of your own and it is having a name, for example, Rachel, and I say Rachel Limited, when I have a problem, I go and sue as Rachel Limited. And also Rachel Limited becomes a person of her own, whereby I can sue or be sued. So you are protected because now it becomes a legal entity. So it's very important to also have and open the business itself by opening a company or registering a business name and having an address so that people know where to find you when they want you to help. Most of the times we also use maybe internet, but also your business name also helps you and your brand to have it registered. So you have to make sure that you have contracts that are also tailored to your legal needs. How do we talk like that? See, for example, you're selling beans and you have gotten a buyer. The fact that you are talking about this already, after you have had that conversation, where will I find you? And for how much? The moment you have done that, you go back and put it in writing and send, so that at all times you have something to hold against the person, and the person has something to hold against you in your business. So most of the times, if you are not able to do this, consult with somebody to do the expert work for you. You say, I have this kind of business and I have this person, and this is how we want to enter into the business. This amount of money, like my colleague had discussed, the terms that you need. These are the terms that we need and the conditions. And also, this is how we have agreed. Also, we have agreed that if something happens, which is the force majeure, how shall we do? Should we terminate the contract, or it shall still continue, but we shall give it some more time and stuff like that? So always make sure that you need to know and also to understand the kind of businesses that you need for your business. What are the legal aspects that you need? And you need to pay close attention to this, because at the end of the day, also, if there is investments to come and for people to come into your businesses, these are the small things that they will look at before they want to agree to what? To invest in your businesses. For example, do you have a contract with the people that you're working with? If it is a company, how many are you shareholders? If you say we are three, have you all written and done the shareholder agreements? How have you subscribed to this agreement? Is there a share purchase agreement for this? Because most investors, if they are coming to invest in your business and they realize that you all don't have a shareholders agreement from the beginning, it becomes a tricky thing, because at the end of the day, if the people want to opt out and they look to sell shares to people who are outside instead of us selling it to the inside people, and the people who are outside come with an idea that is not what you people wanted at the beginning, it can mess up the whole company at the end of the day. And also, what are these other things? Look at the term sheets, employment contracts. How are you going to be employing the people who are coming to work with you? Are you going to just hire them, just come and work with me? Because if you do, at the end of the day, when they are disgruntled, they will take you to the labor what? To the labor offices, and then you get, at the end of the day, it is you who is charged because you did not have a contract and did not agree. So at the end of the day, it affects you. So you need to have all these things lined up for yourself so that at the end of the day, you are protected. What also, when you have an employer working with you, and it's, for example, software agreements that you have, and in these software agreements, when you're working and doing the same business, you have to have non-compete agreements with them, whereby you tell them, if you're working with me, you're not supposed to go out there and do the same businesses that I am doing. To avoid this thing whereby you're crying at hey, I started a business with this person, he left, and he went and he started the same thing with my same idea. You understand? So we need to make sure that this, at the end of the day, you are protected. So by putting non-competition agreements, all these are the contracts that you need for your business. I am giving Rachel and Rachel Limited, so that you may know. So if I am having I have to make sure that there's a non-compete. If I have an employer coming in, if you're joining me as a shareholder, we need to sign so that even if you're leaving, I'm the first person you have to sell to your agreement. We need to make sure that whenever we're having employers, you don't just bring the person that I know him from this place. We went to school together. Even if we went to school together and he has good intentions, I have to make sure that for my Rachel Limited, we have an agreement in place that I am hiring you, I'm paying you this amount. Not that I'm hiring you and when I make money, I'm supposed to give you a percentage. No, I'm supposed to pay you, and at the end of the day, this is what I need with you. The other agreements that also people look at are leases and tenancy agreements. When you're going to hire a place or a place where you're going to put your business, some people just go in and they don't get leases, and at the end of the day, your business you have built, you have put furniture and everything, then the landlord tells you, I want you out in 1 week, and you don't know how you're going to come out. So you're confused. You're like, hey, but we agreed when we were talking that we are supposed to be here 2 years, and the tenant, the landlord is telling you, me, I don't have any agreement with you. I have people who are coming to pay me more money. So whenever you are going to get something in a contract or going to a business, you are going to run your business and you have a location. That location, you need to make sure that you have an agreement you have written with those people, a lease agreement or tenancy agreement. And in this, that you tell them that you're not supposed to come, maybe my business, I have to be in this place for 3 years, for 4 years, and there has to be renewal. If you want to sell this place, I am one of the people you're supposed to know. I hope we are understanding this together. Yes. So all these things have to make sure that are in place. And also another agreement that you have to make sure is in place is the insurance. You need to insure your product. You need to insure the place that you are in from against fire, against thefts. Because sometimes you can be in a place and then one morning you wake up, you find all your furniture is gone. Insurance really protects you, and at the end of the day, you get this, you're insuring your equipment and stuff like that. The other one that you need to make sure that the contract you need is non-disclosure. You need to make sure that you have these agreements around, because you can be selling your ideas and you do not know. There are so many people that we have come across who went to big enterprises and big companies to tell them and pitch their ideas, and the next day they saw them what? They saw that was the idea that they were advertising, and because they did not have a non-disclosure agreement, the person, they don't even know how to start and where to start. They try to go for the doctrine of passing off, but they cannot even prove that this is their product, because the way the other people have packaged it, they look like they are the original owners of the what? Of the product. So even if the person is telling you, come and tell me, and this is the money that they are trying to offer you, have a non-disclosure agreement. Tell them, before we talk, before I even tell you about my product, this is what I need you to do, what? To have. Because as an entrepreneur, most people take advantage of you. They take advantage of the fact that you are alone and the fact that you need them so much. So they will tighten and squeeze you to corners. And because you think the money is too good to be true, you enter into this, and in a year later, a year or two later, then they themselves kick you out from your product with your own name. The other thing is that we've not even mentioned here, but I'm talking about so many among others, is that you need to have your copyright. You need to register a copyright. You need to trademark your products. You need to have it copyrighted so that nobody takes your idea as if it is theirs. That way, you are able to even earn money from what you have registered, so that you can instead give licenses for people to use your trademark. I hope we're together. You make sure that people are having licenses to use your product, to use your to copyright it, and to also use your trademark. And at the end of the day, it makes you, for example, you can see this gentleman called Simple Boy. Is it Simple? Simple Boy, yes. He made sure he trademarked his word called fresh barida. Baridi, yes. And now, in order for somebody or a company to use it, especially when he knew that the elections were coming up, he decided to make sure that he has trademarked it. If you're going to use it as a way of campaigning, you have to come and seek permission from him and use it. If you can even remember the people, the musicians, how they call them, Sauti Sol, their song was being sung. I think I've forgotten that song. Most of us know it. That's the song? I think some of them. So you can see that the people of a certain party were using the song. And at the end of the day, they said, no, we have not given you permission to use our song. This is our song and it belongs to us. You're supposed to get a license for it. And the license, you have to pay us to sing it. So at the end of the day, you need to know what your business needs to entail so that you are not cheated. The other things are partnership agreements. Whenever you have somebody who is telling you, let us partner in this, let Rachel Limited, I want to partner with this one Limited. You have to have a partnership agreement in place so that at the end of the day, you get proceeds. Even as you're going to do a deal with another company, you can partner so that you are two of you and you come up together to strengthen yourselves. And that means you need to have the partnership agreement, which will help the both of you in order to make sure that that deal works. Otherwise, at the end of the day, the money can be paid, then one person runs away with all the money, and yet you did most of the donkey work. So make sure that all these agreements are in place. The service agreements, service level agreements for the places that you're going to run, for cleaning, for what, it has to always be in place, and it has to be tailored to your need. So at the end of the day, in order for you to make sure that your entrepreneurship journey is not having hiccups, you have to make sure that your contracts are well lined and aligned with the system, and make sure that there is a meeting of minds. Like I said, for every time before you enter into a contract, whatever you talk about whenever you go to a Java, the person says, come, let's discuss this business idea. After the conversation is over, go and write an email. Say, as we discussed like this is what I want us to do. As you said, we decided, okay, let us have it written down in line, because it also shows order. And like I said, before people invest in your business, these are the small little things that they look at before they make sure that they run your business. So you will see that as an entrepreneur, most of the times, these were the problems that you could have been facing without knowing, and how investors were not investing in your business because they are saying that you are a bit disorganized. So these are the things that help you organize your business. Also, when we look at the next one, go to the next slide. Okay. Another thing that the things that you cannot afford to ignore when you are setting up all structures for your business, because every business, as you said, it is tailored. They do not ignore, like we said, all those things that we talked about and the potential risks that can help you in your businesses as we go on. Yes. What are all these things that we discussed before? Those are the potential things that you cannot ignore. Do not ignore your contracts that you're writing. Do not ignore the things that you're agreeing with as partners and friends. Do not ignore the amount of money that you're supposed to be paid. Do not ignore the shares and interests that you're supposed to have. Do not ignore who takes the loss in a problem and stuff like that. And do not ignore, like we say, to protect your businesses as a copywriting and trademarking, as I've already discussed. Do not ignore to put everything that you have talked about in writing, and also the conditions the parties are supposed to fulfill before a term is met. Most of the time, some of us as entrepreneurs, we want to work before we are paid. My advice is that always have a percentage paid before you work, before you do the work, so that you may not work for free. And again, you start spending the whole half of your money running around asking the person to do what? To pay you. And as like my colleague said, always have a way of solving a dispute. The dispute has to always have a way of solving. If you don't have a way that of solving it, even like, for example, if you're going into insurances, look at the lines on how they solve their matters before you sign the insurance agreement. Otherwise, you find yourself going to claim and they are telling you, you reported to us late. Are we together? We need to look at what are the advantages of having a written contract. One of the advantages is that it protects you from any loss and any harm in your business. If you are having contracts by word of mouth and even you fulfill it, the person will say, we did not agree. I did not ask you to give me I did not tell you that you bring me this type of car. I did not tell you that I wanted this kind of thing. So at the end of the day, you are in trouble because you did not have something written down. It is also easier to enforce a party's right where both parties entered into a written contract. And don't forget that whenever you have this contract written, insist that you may register. Because when you register, you'll even get interest when you report the person to court. They will pay and it will be enforceable. Are we together? So you make sure that all these things are in writing, and at the end of the day, if one party has not done their part, and yet you've done your part, they will pay you and pay you with interest. So have your contract written down. It also sets out the scope of rights and obligations of the parties. Why? So that you may not do more than you have been asked to do. Or you may not, the person may not do and may not underdo what you asked him to do. I told you that I want you to deliver for me these beans and I want them to be delivered on Tuesday. Because on Tuesday is when the other people are supposed to eat in school. So you're there, you're delivering beans on Wednesday. People in school on Tuesday were starving. So what is the purpose of that? Because they decided to look for sukuma to eat. So your beans are not needed. So if this person is demanding for payment, it means they went beyond the value that they were supposed to do, and they may not need to be paid. They may ask them to go back. So it makes you to understand the rights and obligations of the party. Likewise, if I deliver my beans on Tuesday, like you said, and then you tell me, and then that is what we had agreed, and then you tell me, but I told you to deliver on Wednesday, I will not pay you. You ask the person, pay me because you told me. This is what we agreed and we wrote down, and you signed here, and we signed here, and you had a witness, and this one witnessing. Are we together? It also prevents any miscommunication or misinterpretation of any terms in the contract. That is why in a term in the contract, there needs to be definition of terms according to the understanding of both parties. That is why you say, for example, offer means that you have said this and I have accepted. This one means that. Then it said, sell means that you have brought for me your beans and I have delivered and this, so that will be constituted as what? Consideration means the amount we have agreed. So when you understand the communication and you say, for example, the beans have to be delivered before lunchtime or by 8, because 8 we need to have soaked the beans and cooked them. The person must have already delivered them at that time. So misinterpretation works when you have your written contract. Also, like we said, you have to make sure that both parties understand both terms in agreement and also understand where there's a misinterpretation. How are you supposed, for example, someone will send you a contract to read it and want you to sign it. Always, because it is for the meeting of minds. Both of you have to understand and agree. If you've not understood a term, ask, what does this mean? Break it down for me in a way that I may understand. Otherwise, you'll find yourself signing agreements that you never even knew, and you thought in your mind, you thought that this one means this, yet in actual sense, this means that. For example, when they say business working days, you might think because you work on Sunday, or because some people you have a Muslim, you work on this and this day, on this day you don't work, yet in actual sense that is a business day. So you're counting backwards, yet instead of counting forwards, and at the end of the day it may affect you. So always ask to clarify so that there is no miscommunication and misinterpretation in an agreement. Are we together? So as we have said, what are the disadvantages of not having a written agreement? Where parties fail to enter into a written agreement, there is a risk of disputes arising through misunderstanding of terms and miscommunication. That is why you will find that people are saying, but I sold to you my land, and especially land agreements. I told you we agreed that I'll sell for you from this part to this part where I have grown the tree. Remember, trees dry up. Trees will get blacked out. Are we together? So where you said this is where you wanted it to start, the person is increasing. They're entering, encroaching another person's property because you did not get it clear. You are saying in a land agreement, say, I'm selling to you a quarter of an acre in this place I have valued. So if the person is starting to increase or reducing, giving you an eighth, there's an agreement here as an for you. And so if you don't have this written down, and these terms, because of it's called the gentleman agreement of handshake. In the world today, gentleman agreement and handshakes, they may not work for you. At the end of the day, it may end up making you bitter and upset and may make your entrepreneurship journey very difficult and hard to achieve. So you find people failing at the end of the day. And as you can realize that most of the failures are happening because there were legal things that did not cover. Anything that you realize, if you agreed and the person failed, that is already a legal matter because it means you did not write down and the person has breached the contract. So if you had written it down, it would not affect you. So you will realize that for every journey, you have to know the legal knowledge and the legalities that have to what? To work with the contract. Other things that lack of written contracts means there is no means to protect your startup or an entrepreneur's confidential information, like we said earlier on. Whatever you bring to the table, if it is not protected, the other party will run away with it. Or even there are other side people who are with them, they will run away with it. And at the end of the day, you'll find that you're shortchanged. There are so many ideas as entrepreneurs that we have that can be taken away and be built in other big places because they have the means. You don't have the means. So protect yourself so that they also help to be what? You will be helped through the means. As you can see, there was a recent case of a lady whose picture was taken, and I think they used it to advertise. There was one where they advertised the tea. She was almost like a nobody, but the tea made profit. At the end of the day, she was paid 1.5 million at the end of the day. So she had 1.5 million reasons to rejoice. Because if she was an under, those people did not agree with her and they did not put it in writing. And at the end of the day, she was the one who was alikuwa ameumia. But because she fought her way out and she told them, but we did not agree. Though the people said, no, but you did not protect, we don't have your picture. She said, no, my image is my protection. My image is my right. So you have to pay me. And at the end of the day, they pay the person. So make sure you are protected. You are protecting your rights. You are signing all the time. The people that we always advise, whenever you have an idea that is good or a business, I tell you that logo, go and register it. Otherwise, you'll find it in someone's what? In a very big business, and you'll find it so hard to fight them. So also in the event of a dispute, the lack of written contract proves difficult for any party to enforce their rights. Because if it is not written down, even if you go to court, it is so hard for court to help you. You agreed on this amount. The person will say that we did not agree. How will court give you interest for the loss? If you started the business, you said you did it from 2019, and the person has not paid you until now. You might only get the amount of money, but with court, interest are supposed to be given to you from the day 2019. So you find that the investment that you made, it is already a loss of energy, a loss for you on the mind and everything. So we need to be very, very careful when we are doing businesses on this and everything. I think that is all for our entrepreneurship journey. And maybe the floor is yours if anyone has any questions.
Great, thank you very much, Njomo and Rachel, for giving us an incredibly informative session. We want to jump into some few questions, so please keep sharing them on the chat on the questions tab. But we had one really brilliant one that came up from Josephine. And essentially, she was asking, how does this apply to non-Kenyans who are looking to operate inside of Kenya? Ideally, for us who are local citizens, we can have some good bit of understanding in terms of what all these legal terms and legal contracts mean for the Kenyan setting. But for someone who is outside of the country and is looking to get into all these contracts and agreements and find ways of doing business locally, do all the same rules apply, or are there any particular things that foreigners should be looking out for when it comes to looking through contracts and agreements and how to run business processes in the country? Jomo, if you don't mind, you can please take that.
Thank you, Victor. And thank you, Josephine, for the question. So basically, in this country, there is really no distinction between a local and a foreigner when it comes to carrying out business and under the requirements of the law. The only thing in this regard is the same know your customer requirements that are required of a local are the same that are required for a foreigner. Now, the trick is for the foreigner then, for example, is coming in to invest in a country, they may think, okay, I'm not used to this country, I don't know anything about this country. Of course, for them, they also have to do their due diligence, as stated earlier, first in the form of understanding the business environment in the country. The second part they'll have to do is understanding who or doing a very in-depth check into the people who they're going to collaborate with. Now, whereas the foreigner is able to incorporate a company in Kenya and own it by themselves, for example, or then also incorporate locals, there are some specific industries where there's a requirement for local shareholding. And so in this regard, the choice of a local partner becomes very critical for them. So all these due diligence requirements that are carried out on the company should also be carried out on the person. Now, a lot of these requirements are you can find, for example, when you have to open a bank account and they'll tell you, give us your PO box and give us your email address and your number. So the same thing should be done both by the foreign investor on a company in this country, and also on any person whom he or she wishes to partner with in the business. Of course, for them, it becomes more critical because, for example, they're bringing funding from outside the country. Now, a lot of times you find that when the funding is being sent to this country, you find that their bank, for example, will require some sort of due diligence or some KYC from the local bank here before the payment is done, and that is done in the form of the SWIFT payments, the money transfers. So you'll find that then the source of funds is also validated. But then after that, then the foreigner has to then also engage local counsel, local lawyers, local tax advisors, financial advisors, to guide them through on a step-by-step understanding as to what the requirements of business in this country, and for them to also understand their needs. For example, you'll find that there's some things that they may be able to do immediately. There's some that may have an issue in carrying out because, say, they need work permits, immigration issues to be processes to be followed out. And therefore, for example, they're not able to start a particular business, or then start to work in that business at some point until such immigration processes are followed out. They have to apply, for example, for an investor's permit or a work permit to work in the country. So all these things they should then get advice on before they start, so that then there's a timeline provided. Then they have a realistic expectation as to when they can actually carry out their business. And as I said, now when it comes to them also investing in the local company, they also need to take into account the advice of those local advisors, get detailed legal opinions, especially because it's a country that they're not used to, and as much as possible, spend time in the country before to understand the business setup and its operations before they make the decision to invest in a company. Noting that, for example, that if in the event that anything goes wrong, then their investment is at stake. And for them, it may be, for example, the fact that the funds have come from outside the country, and therefore they may have taken a loan from outside the country, or they may have gotten funds from other persons outside the country. Now come other issues relating to the recovery of those funds, and whether there is a way they can institute a legal suit or case against against the business owners here to recover those funds. So in a nutshell, basically due diligence applies to every person, whether a local or a foreigner, and it is imperative that, for example, that each party engages those advisors to get that advice. A lot of times people say, no, but it's expensive. Lawyers are expensive, accountants are expensive, tax people are expensive. They may look expensive at the beginning, but sometimes this expense is what saves you the cost later on. Because sometimes you may end up making a mistake later, and then you ask, but why didn't you engage a lawyer to do a search, to do a due diligence, to do a background check into these individuals, into the company before they invest in the company? Or in the same for a local, if they're bringing a foreigner on board, did they do the proper investment to ensure that this person, the proper due diligence to ensure that this person I'm partnering with, or whose investment I'm accepting, is qualified to do, is allowed to do business in this country, is meet the requirements, has met all the KYC requirements, and that the person is who they say they are. So at later, my business is not caught up in a web of issues arising from the fact that I made in choosing the person to receive money from or to partner with. So as I said, it may look costly, but it's worth the cost in the end. And I advise any person starting off to basically engage those individuals, those advisors, to help them through their journey on this. But nobody should then be scared of investing or look to financing a company in this country simply because they feel they may not get enough information. There's a lot of information available on the World Wide Web. There's a lot of information available through searches, and the business climate is now set up in a way that I think each person's interests are able to be protected, and the investment bear fruit. Thank you for the question.
Amazing. So there was a follow-up question by Josephine on whether you do offer these kinds of services yourself. So maybe as we are closing up, you can just tell us briefly about how Netsheria can help businesses and entrepreneurs to be vigilant with all these business processes, and also for them to just be aware of the kind of documentation and contracts that they might require to either start or run their businesses.
Thank you for the follow-up question. So Netsheria is basically an online legal portal. Through which one can obtain a variety of legal services. The first service they can provide is access to they can get access to is legal documents of various forms. We talked about agreements and contracts which have to be entered into. So at Netsheria, we've tried to come up with various legal templates, applying to a variety of business operations that each operation then will require, for example, all the way from company incorporation, all the way to the basic contracts for starting up, to employment contracts that you need for your employees, to the contracts you need for your consultants, should you need to get any, to the policies you'll need to draft to set up your business structures, and all the way to financing contracts that you need, your basic loan agreements, that you'll need to obtain your financing. You'll also have intellectual property contracts, the basic requirements and contracts and agreements for copywriting and trademarking, as Rachel had talked about, and the processes and costs. So those documents are basically are in a portal form, in a portal where any person who then signs up can make a payment of an amount and then get the relevant document they require for their service. Should you need to have that document, for example, customized or further information added, we also have the legal consultation feature within the portal. Sorry, all these are within the website, www.netsheria.com. And as I said, so then the next part is a consultation where you can then engage the advocates within Netsheria to further customize the document or get further clarification on any issues which you may need advice on. And those consultations are paid in various timelines. So you can have consultations for 15 minutes to 30 minutes, 45 minutes, all the way up to an hour, and each of them are costed based on the duration. The third part is something that is more applicable for a wide variety of startups and business operators, which is now the Entrepreneurs Club. This is ideal for the startups and growing and established businesses, where we then say, we know that you may have a wide variety of legal needs, all the way from incorporation all the way to the basic day-to-day legal operations, to your intellectual property registrations, to data protection, to where need be debt recovery, where you have debts to be followed up, and business structuring. So basically help you then structure your business from inception all the way to growth. So under this model, then a business owner is able to pay for the services on a retainer model. So this can be paid for in a monthly, by quarterly, biannual mode, and the payment is basically then determined by the turnover of the company and the number of employees. But it ranges all the way from 19,999 to 149,999. So it basically captures a wide variety of businesses of all scales, and in this way, then you're able to obtain that variety of legal services instead of paying for each service on a case-by-case basis. So as I said, then you please feel free to reach out to us on website, or you can write to us on info@netsheria.com to get further information from us. You can call the number indicated on the screen before you to then reach out to us and then see what service you require. We'll help guide you and customize your business requirements as per your needs. Thank you.
Thank you once again, Jomo. I think we have one last question from Kenneth, and then we're going to close. And he's asking, does patenting a brand guarantee that any idea developed and registered under it is also secured? Does patenting a brand guarantee that any idea developed and registered under it is also secured?
When you patent an when you patent an idea or trademark something, whatever agreement that you have after that, see, for example, when you have, I want to give it an example, a software. When you develop a software and register and patent it, anyone that comes to use it, first of all, knows it is yours. But there are certain agreements that you, for example, if someone comes to redevelop or add something to it, and it's their idea, There, for example, when you go to work, let us say you're an entrepreneur, you are a software developer, you go to work you go to develop a software in another company. If you don't have an agreement with those people, they may tell you that whatever thing that you have done will belong to them because they have hired you for that time. So that one also is subject to the contract that you have written together. Unless you go specifically say, I have come as a consultant and this is my idea for you. And also when people come to work for you, whatever they are coming under you belongs to you, as the agreement states. If you've not written it down, they may get away with it. I don't know if I've answered that correctly.
Perfect. And thank you very much once again, Njomo Kamau and Rachel Linga from Netsheria. This has been an incredibly informative session. Thank you very much also to our attendees for joining and staying with us through the session. We appreciate your engagement. We appreciate your time and your commitment for being with us. And because we want to appreciate and acknowledge you, Nairobi Garage will be extending a free day pass to all of our attendees from today. You can feel free to go to any of our locations and work for the whole day for free on us. Once again, we have locations in Kilimani, Karen, Spring Valley, Westlands, and in the CPD. So we will be sharing that with you on email. You can feel free to hop into any of our locations and work for the whole day for free on us. So now, as we're coming to a close, I just want to wish you all a great day ahead. Thank you once again for joining us. We're going to be having much more of these sessions happening throughout the rest of the week and throughout the rest of the month. Please follow us on all our social media pages at Nairobi Garage, and you can get to see all that is coming up and all that we're going to be doing. Thank you once again. I have been your host. My name is Victor Mutama, Community Manager at Nairobi Garage Spring Valley. Do have a wonderful day, and thank you so much for joining us. Kwaheri.
Thank you, Victor.